We'll hear argument first this morning in Case 13-975, T-Mobile South versus the City of Roswell, Georgia.
I think we would have a much different case if at the time of the written notice they appended the official copy.
Fisher's argument. And what's your answer to that?
I want to make clear that we're not saying that when you look through the written administrative record to determine what the reasons are, that you read through the whole transcript and that anything that came up during the hearing, like what happens when the power goes out.
How does it work in the ordinary agency?
Okay, as long as if everybody gives a different rationale, as long as you can get to a majority, you can conduct substantial evidence review of each of those rationales. And we think that makes sense here because the statute gives reasons why you can't deny an application. It doesn't say there are only certain permissible reasons why you can't.
Doesn't the Administrative Procedure Act require providing reasons when there's a grant or a denial?
Yes, and we agree that reasons are required. The question Justice Breyer was asking was, what if you don't have a majority in support of any particular rationale? And the response is, we've cited some cases in footnotes.
Don't you have to give the reasons with the decision under the APA?
Yes, but
so how can you give it if there is no majority for any single reason?
You would give the rationales of each individual council member. It's not a problem.
Has this court ever held that? Because I would never hold that.
No, it's not.
That's absurd.
Justice Scalia, we cited some cases in footnote 6 of our brief that indicate that other courts have allowed that to occur.
I'm a little bit confused by that because, and this is what troubles me the most. You get 5 council members, 5 different reasons. At what point does he win? Meaning, if he proves that 3 of them were wrong in their reasons, so there wasn't a majority vote for anything, that's what he has to do?
There weren't a majority of council members that gave a reason that wasn't prohibited by the statute or was not supported by substantial evidence.
That's
and it's not a problem that's unique to this particular context. That comes up sometimes in agency decisions where there's a multi-member body that's heading the agency. The cases in footnote 6.
Do you want us to write an opinion that says under this act, agencies have to comply with SEC versus Chenery, or pardon me, city councils have to comply with SEC versus Chenery?
We think that by requiring that decisions be in writing and supported by substantial evidence, and then also by providing for judicial review of those decisions, implicit in the statute and explicit in the legislative history is that the local government has to give reasons.
Either under general laws of zoning or under any similar federal statute, has the federal government ever imposed requirements like this on a legislative body?